here. Great. And so before we get started, I do have a little disclaimer in the chat that you can read, but also I just want to state that this webinar is general information. It is not legal advice for a particular case. And for such legal advice, people must consult a Massachusetts licensed attorney of their own choosing. So we just wanted to make sure everyone knew that. As far as who we have here tonight, I am April Williams. If you've been to our events before, you've probably seen my face. But I am the head of marketing for Backyard ADUs. So I do all the newsletters, social media, and these events and in-person events. With us tonight, we also have Tim O'Reilly. He is our pre-construction manager and also does small home advising all over the state of Massachusetts. We also have Rick Bartlett, who is also a small home advisor and is also all across the state. What'd you say? Provincetown to Williamstown, he says. And then we have Michael Pill. He is a partner in the Northampton law firm, Green Miles Lipton. He specializes in land law and is the current author of a multi-volume legal treatise entitled Massachusetts Practice Real Estate Law. A significant part of his law practice is helping people who want to build and overcome municipal obstacles, neighbor opposition, or both. So he is our guest this evening, and we're so glad to have him. And with all that said, I will turn it over to Tim.
Wonderful. Thank you, April. And thank you everyone for spending your time on this evening to join us. We've been getting a lot of inquiries and a lot of questions about what is this Affordable Homes Act that the governor signed into law in August. So we're really excited tonight to both combine our sort of expertise in the accessory dwelling unit space in the construction world and Michael's background with law so that we can help disseminate this information and point people in the right direction. And most importantly, answer your questions. So these events are successful when you use that Q&A. So please don't be shy tonight as we kick off. So I'll share my screen here and we'll get started. So if you haven't been or seen us around before, we are Backyard ADUs. We specialize in accessory dwelling units and small homes. And we generally cap our range sort of at 500 square feet up to about 1,200 square feet. So 1, 2, and 3 bedroom homes. And we've learned a lot over the last years about the nuts and bolts of how to not only design, but to permit and to build them. And at the crux of the Affordable Homes Act here, we're going to be talking about what are the changes, both on the ground construction-wise and also in that permitting process across the state. So the governor signed into law in August or passed the Affordable Homes Act. There are many provisions in there. There's a lot of funds. There's a lot of great things done for housing across our state, whether it's affordable housing or accessory dwelling units. We're just going to focus tonight on those changes with ADUs. And at the crux of it is setting a baseline standard for every single town in Massachusetts about what they need to allow and what their options are for adding additional requirements when it comes to accessory dwelling units. I've gotten this question a lot. What do you think about towns still being allowed to add in their own requirements? And generally it's okay, right? We are all, New Englanders. We have our unique towns with unique characters and histories. And so it is all right for towns and officials to add in the layers of requirements that they feel is necessary. But more importantly, having this baseline across the state is going to make this form of housing accessible and more accessible to everybody. We've really felt it since August. This is looking at in the background of how many inquiries we are receiving every week. And you can see this big spike here as we came through August and into September about how many inquiries, almost 700 a week, or the monthly inquiries. And that coincides directly with the passing of the Affordable Homes Act. So first and foremost, what this act has done is gotten the word out there. It's headlines in all the papers and online, and the awareness is really building for what is possible and what you can do, which is awesome. So what is an ADU? When we get down to the nuts and bolts of it, we're looking at several different forms of housing. An ADU is an accessory dwelling unit. It is not the primary dwelling on the property. It is accessory to that, but it still is a dwelling. And we'll look in a second at what that means in terms of code. But how that can look on your property is many different forms: detached, attached to the primary dwelling, an interior conversion, whether that's an attic or a basement. It can also look like a garage conversion, taking what's now a garage and turning it into a dwelling, into living space, or adding space above an existing garage. So it takes on many different forms. The key here is that it is accessory to the primary dwelling. There are many benefits here, and that's both to all of us here in Massachusetts, but also to property owners. So why did the governor include this in her historic act? It's because this is going to allow more homes to be built. We know the issue with the housing crisis is a lack of stock and a lack of affordability, and ADUs are threading the needle here. We're allowing density, and we're also generally cheaper than if you're building a standalone new house. These can also, as we're doing infill, be more accessible, and we're maximizing infrastructure and land that already exists. We're not talking about building up and building high rises. We're not talking about clearing more land. We're talking about using the parcels and the infrastructure that already exists. Practically on the ground, we're meeting all the requirements for HERS ratings, but just generally who's occupying these, they're more efficient. They're airtight, they're well insulated, and per occupant, we're just using more energy. So as we're looking ahead, what is our impact in terms of energy usage and carbon? These are, a good option. Property owners are also going to benefit greatly from these. Not only, hey, having this accessory unit, you can now potentially rent it out. It's allowing families to stay together and live multi-generationally on the same property. And as our boomer population is aging, it can really help for costs of caring for aging relatives and childcare costs. Folks who are in their homes, we know with how the rental market's been over the past couple of years and interest rates, some people are trapped. They're stuck in their house. If they sell, they may not have a place to go, especially in their own community. So an ADU might be a way for them to move into a more attainable, more accessible form of housing while opening up, the primary dwelling, or vice versa. So there's a lot of flexibility there that it can give a property owner in a single family residence district. The nuts and bolts of this I went in there, and this is copied directly from the act of what passed here with the governor on August 6th. So getting into the nuts and bolts, there's 3 pieces here that we're going to focus on tonight. So you're seeing the language that is passed that is in the Affordable Homes Act. And again, that accessory dwelling, that first sentence talking about a self-contained housing unit, is we're always talking about a place to sleep, a bedroom, a place to cook, and then a sanitary facility, so a bathroom. So what's separating an accessory dwelling from just an addition is that this dwelling has all 3 of those pieces. The classic example before ADUs were allowed by right is, hey, my town doesn't allow an ADU, but I can absolutely add an addition onto my house. And it's not a dwelling because I don't have all 3 of these full facilities. Often people would target cooking and say, hey, I'm going to get rid of the range. I can have a fridge and a sink, call this area a bar, but I'm not a full dwelling. So now across the board, with accessory units being allowed by right, you can have all 3 of these facilities in that dwelling. The crux of this law are these 3 headings, I, 1, 2, and 3, and we're going to go through each of these in detail. And Michael, feel free to chime in here as we walk through, because we're really we're lucky to have you tonight with that legal lens on what are the nitty-gritty pieces in this language. And the last piece here, as of right, we're going to get into what does it mean to be by right versus a special permit, and how that sort of changes the game, not only from a risk perspective of your ADU project, but a time perspective.
In a nutshell, what it means is that before this law was enacted, a municipality did not have to allow ADUs. They didn't have to allow them at all if the town meeting or the city council didn't want it. And if they did allow it, they could do it by what's called a special permit, which is a discretionary case by case analysis that always requires a public hearing, notice to all abutters to abutters within 300 feet. So if you've ever had a tiff with your neighbor, this is where it will come out. And even if you've been nice to them, it may turn out that they don't want another dwelling unit in your backyard or, closer to their house, increasing density. With a special permit, the local zoning board or planning board could deny it as a matter of discretion, which means in plain English, if their reasons for denial were not completely bouncing off the walls, what the law calls arbitrary and capricious, there was virtually nothing you could do about it. Now, what this law means is that ADUs are a matter of right statewide, and the only conditions can be put on are through what's called site plan review, which means they can impose reasonable conditions, but unless there's what the law calls an intractable problem. I guess one example might be you have no room for a new septic system. You don't have public sewer. You can't put a new septic system in. That would be an intractable problem that would enable them to deny you. Other than that, by reasonable conditions, that means they can't load it down with conditions that amount to a denial. And so this, as Tim has been noting, is a huge sea change. It's now by right statewide. Thank you.
And that you hit the nail on the head, Michael. Is that by right? That's what's leveling the playing field for all of us here in Massachusetts. The easiest one here is the first one. Is they're allowing and clearly stating this accessory dwelling needs a separate entrance, and that can look a lot of different ways. So all of our different varieties of how an ADU can be built, that detached unit will have a separate entrance. If you're attached to the unit, you can have that exterior entrance. You could also have an interior entrance. The key being, you need to meet the requirements of building code for egress to make sure that there's safety. And then same with the interior conversions, whether that's an attic, a basement, or a garage. There can either be an exterior separate entrance or one into the dwelling. Backyard ADUs builds a variety of these. We're often building detached or attached to the main house. And we are, meeting these requirements. So there is two means of egress for fire code, whether that's in a detached ADU or the one in the bottom right here is attached to the main house. And so a lot of different ways you can look at it here. It can be, a covered porch. You could have a portico, but in plain English, hey, this needs to have the proper means of egress. You can be detached, you can be attached. Another note as well, you can build a garage as part of this. A garage is an accessory structure, and what is now allowed by right is the accessory dwelling. So you'd still need to meet the requirements for an accessory structure if you were building a garage as part of this. And in most towns, that is already a by right process. The key and the question I think I get asked the most about is size. How does the Affordable Homes Act and this new definition of an accessory dwelling unit change the cards for how big an ADU you can build? And what's in there is, again, a baseline. So they have set a maximum size at 50% of the existing house's floor area or 900 square feet, whichever is smaller. And this was some language when I was talking to folks before the law was passed. I strongly lobbied against. Someone with a smaller house is penalized here to not be able to build, a 900 square foot ADU, which when we put our designing hat on is a comfortable 2-bedroom ADU that would allow for accessible or ADA features. But that's my opinion. So what does that mean for your town? There are towns across the state right now that have more generous rules than this. There are towns that don't allow this or that have more restrictive rules. So the leveling of the playing field here is setting this baseline size. So if you have a house that's bigger than 1,800 square feet, 900 square feet should be your maximum size. If you are smaller, what does that mean? And we'll look at that in a second. But towns are actively working right now to update their rules. So before this webinar, I made a couple calls to planners in towns that we have built in before across the state. Concord stood out. They right now have 750 square feet by right. Nothing is set in stone here, but they were talking about saying, hey, we just may set 900 square feet by right without the proportionality. And the reason for that, in my opinion, right now they allow 1,000 square feet by special permit, but they no longer can allow that. It can't be a special permit process. So they have to go in and change their rules. So they're thinking about setting just a flat amount. I talked to the planner in Falmouth. They had this crazy calculation where, it was X percentage of the second story if you had this roof type, and X percentage if it's this roof type, and you had to do some math. And the last project we built there, I think it took 3 different people's opinions to figure out how big of an ADU we can build. So luckily that's getting rolled back. And Northborough is another town we built in. They allow 800 square feet by right. And when I was talking with their staff, they're debating, should we just go right up to 900, or should we also include this proportionality, which would, impact some of our residents? So again, your town will still have some discretion, but they must meet at minimum this new baseline.
So I have a question that came in too. And the question was, so if towns have a max of 1,200 square feet, does that mean they need to scale it back?
No.
Yeah, Michael, do you want to speak to that?
No, I don't. Generally, local zoning can be more liberal than the state law. We are what's called a home rule state, which means that you can have zoning that is more liberal than the state zoning act. Now, that said, what a court might do is anybody's guess, but here's where the policy of availability of affordability of housing comes in. The argument I would make is that we need to go whichever is more liberal, and there's other areas of zoning law where that's the way it works. You either go with the state law unless the local zoning is more liberal. Another way to potentially enhance what you can do is the phrase gross floor area. It doesn't say habitable floor area. Now, a local zoning bylaw may or may not define that, but the argument that I would make is gross floor area, for example, would include a basement. Now that's something, again, that in our legal system, the courts may end up having to speak to. But if, for example, you live in a 900 square foot or 1,000 square foot post-World War II bungalow, I would say, well, if you've got 900 square feet on your 1-floor bungalow and a 900 square foot basement, then your argument is you have 1,800 square feet of gross floor area. But again, that's subject to what a court might say. It's also subject to how the local zoning bylaw might define that term. This is what lawyers do. We look for mouse holes to drive trucks through.
And I see this a lot in bylaws across the state where in their definitions of gross floor area, they may or may not very clearly state what they're counting. And would that be that pathway? If they said, hey, we don't count a basement, then their home rules rule?
Yes, I would say so. But again, the problem is, do you want to fight? Which can cost tens or even, tens of thousands or even 6 figures. It can delay a project for years. It's not something you do unless you absolutely have to. So if you can live with whatever size the municipality's interpretation will allow, you're probably better off to do it. I like to say the best lawsuit is one you can avoid, and in any lawsuit, the only sure winners are the lawyers.
That's I've never heard that. That's great. And I've seen in a couple towns designing, building, and permitting that some towns state very clearly, hey, you can count this, or no, you can't count that. So that would be a case I would, maybe consult the definitions section or talk to your local planner to say, hey, how are you guys going to calculate that, gross floor area piece?
There's no substitute for reading. Lay people, I think, are inclined to want to talk to public officials, but zoning ordinances and bylaws are almost always online. And if you find yourself getting lost or it seems like drudgery, it is. It is not very exciting reading, but there is no substitute for following the 3 rules: preparation, preparation, more preparation. Like he said, you want to look, for example, for the definitions section, and you want to try to read it. And if you're not clear, then you might ask the building inspector, or if the town or city has a planner. Thank you.
And that's the kind of work that Rick and I do as small home advisors. So if you're not sure, feel free to reach out to us. And we do that work to sort of dive in and take a pass and say, hey, what does your town allow? And what's your property card allow? I'm realizing I moved the image here, so it's not circling the correct number here. But I just went and pulled a property card to look at, basically, hey, your finished area here, what's on your property card? 1296. So someone who might be in that proportionality would then go and calculate half. Hey, 600 almost 650 square feet. That's a very comfortable sort of 1-bedroom ADU if your town was going to adopt that proportionality. So from our lens, looking across the state, consistency is key. Right now, you have to go and read 365 some odd bylaws with all our different towns here in Massachusetts. Even though we have this leveling of the playing field, consistency across the state will be helpful to actually have ADUs make more of an impact on our housing crisis. But again, and we'll talk about later, how towns can come in and add, their layers to the law here. So some will take this language as is, and others will modify it to fit their needs, just like we talked about. The third part, and this is getting really into the nitty-gritty stuff, is what is the state saying all towns must allow, and where can towns come in and layer what they want? So municipalities no longer can require owner occupancy for the ADU or the principal dwelling. This is historically been one way to prevent ADU development. So this is hey, someone, the owner, has to live in one of these units, and that precludes some portion of the population where that is not the case. Municipalities cannot, like Michael brought up earlier, introduce a special permit or discretionary zoning approval for the use or rental of the ADU. Then parking. Parking is also a classic way to shoot down ADU projects by requiring parking, which some lots may not be able to support. So there is some discretion here. If you are within half a mile of public transportation, and specifically the commuter rail, the T, the ferry or bus station, there would be no parking requirements. The town cannot come in and layer that in. If you're more than half a mile away, they're saying that, hey, you can require one, but you can't require more than one. And I've actually worked on a couple projects where these parking requirements saying, hey, you need X number of parking per unit. Now we get into setback issues and lot coverage issues. And it's like, oh, we actually can't build an ADU here. Not because the ADU doesn't fit, not because we don't have the utilities, but we don't have enough parking to meet this bylaw requirement. So these are all really exciting. Do you have anything to add, Michael, of the importance of these?
Just that they can impose reasonable requirements. And what is reasonable? I call reasonable a classic lawyer's weasel word because it depends upon the circumstances of a particular case. One of the best examples I ever had was um, in a town where you had to have 250-foot wide lots, a 25-foot setback. Client comes to me with a 19th century house built on a lot that predates zoning that's only 50 feet wide, and they want to put a building in their backyard. What we argued was that 25-foot setback may be fine if you have a modern 250-foot wide lot, but for this case, as applied, it's invalid. And so if, for example, the municipality tries to impose cookie cutter requirements that may not fit your particular situation, depending on how long you're willing to wait, how much money you're willing to spend to fight it, it's an option potentially to consider. Thank you.
And so this is where providing a little more color to that is like, hey, what are the ways that the town can restrict? So site plan review, we're going to look at this in detail in another slide. So I'm not skipping it. But Title V requirements. So a lot of our state here is not on public sewer. You know, whether you're in Western Mass, you're on the Cape, or you're in some of our more rural communities. But the municipalities may come in and say, hey, you need to make sure you're meeting all of our state rules and requirements when it comes to your sanitary disposal system. So putting our builder construction hat on, we deal with this all the time. Say, hey, what's in the ground now, both the tank and the leach field? How many bedrooms or rooms are there, depending on how your health agent is interpreting Title V? How many are we proposing to add? And what are the modifications or adjustments that need to be made to either add bedrooms or convert bedrooms to make sure all those Title V requirements are being met? They can come in here and add regulations on dimensional setbacks and the bulk and height of structures. Have you seen any of those come across your desk, Michael?
Not yet, because I think it's because we're not at the February 2nd, 2025 effective date for the by right business. But I expect we will see a fair amount then. And are you going to get to that effective date? Because there's a point I want to make about automatic invalidity.
Yes, I have that at the end here to talk about,
Okay.
hey, what are our next steps?
Stay tuned, folks.
And one of the planners I was talking to, they were talking about putting in a height restriction for these ADUs. And their rationale, I think, was going back to another thing you see in ADU bylaws and talking about how this accessory unit must fit the character of the neighborhood and be accessory or subordinate. And this planner was trying to propose that, hey, if I limit the height of ADUs, they can only be, 20 or 25 feet tall. It is going to feel smaller and subordinate to that principal structure. So you may see things like that come through. And that's what your town is probably talking about right now here. As like Michael said, we're barreling towards the February deadline. The last thing that you'll see and that the state allows here is towns can come and impose restrictions on short-term rentals. This is a real hot topic on Cape Cod, and I'm sure in other parts of the state where we have seasonal communities where short-term rentals do benefit some, but also have other impacts on the community. So this restriction helps all of our towns basically discern, do we want to impose restrictions here in areas where short-term rentals can cause problems. So I'm excited to dive into this one, Michael, because you do this for a living. I do this sometimes, but not as much as you. And I'm hoping I have my last one here in November, a special permit for an ADU. So I really wanted to dive in here and make sure we very clearly distinguish what this change is of eliminating special permits, but towns can come into a site plan review. Do you want to give us just a quick overview of what each of those are and the purposes they serve?
Yeah, special permit is a middle category in zoning. There's uses by right. Single family house in a single family zone. You go get a building permit, no public hearing, no notice to the neighbors. You build your house. There are uses that are prohibited, right? You can't plop a landfill in the middle of most residential neighborhoods. You can't plant a tannery or something that, or a something that will stink the neighbors right out of their homes. In between, for example, maybe a gas station, a store, an office building that may be allowed on a case-by-case basis. In other words, zoning is yes, no, and maybe depending on the circumstances, if we feel like it. That's what a special permit is, and that's what discretion means. They can grant it or they can deny it, and whichever they decide, I generally tell people who want to challenge it, it's pretty tough to challenge an exercise of discretion unless they are bouncing off the walls. Now, site plan review varies tremendously. In some municipalities, you just go to a public meeting of the planning board on your way to get a building permit. In other municipalities, they have adopted all the special permit formalities, even though it's now for a use by right that they can only condition and basically cannot deny. That means they give the same notice to abutters to abutters within 300 feet. They publish notice in the papers. In some municipalities, they put a sign in the front yard so everybody who drives by knows about it. And that can have a big effect in terms of how people may respond. If you're in a municipality where site plan review is just a regular business meeting, it's a lot less likely you're going to have neighbors causing trouble. And in the real world, a lot can depend on who are those neighbors. Did they contribute to the mayor's campaign? Are they related to the mayor? Are they good friends with the mayor? Or in a town, the planning board members? I mean, I'm trying to be realistic about how the real world works here, and that's where you may have to invoke the law. I have one case now where a board member said, well, all the neighbors were opposed, so isn't that basically a popularity contest like an election? So I'm voting no. And we're still trying to explain to that uninformed board member, no, you got to follow the facts and the law. Thank you.
And that's why I put in here, it's often a formal rubber stamping. That site plan review, the rules are laid out very clearly. Most of which hopefully now we've gone over, hey, this baseline from the state plus what the town layers in. But those rules are laid out. You're doing everything you need for a building permit, whether it's, a septic design and Title V stuff, an official survey, architectural engineered building plans. But that process can get heated. If a town, I'm thinking about one that I did last month, it is a site plan review. It is with the planning board, but it is, like Michael said, notifying the abutters, sign in the front yard. People can still show up to that hearing and express their opinions. But at the end of the day, it is that planning board reading the letter of their rules, reading your application, and do they match versus on that ZBA of being a little bit more of the court of opinion.
And if you are in that situation, mind the old maxim that honey draws more flies than vinegar or poison. They have a constitutional right to spout off pretty much whatever people like, okay? And so it's always best, keep your voice down, keep it not personal. Thank the neighbors for their valuable input that you greatly appreciate. You may or may not want to change your project, but it's just trying to let people know that they've been heard, especially if you're not going to change the project. And you may want to go back to the ADU people and say, well, is there something we can do to modify it? I don't know how often you get into that, but where you can mollify either a board or the neighbors.
Yeah, it's actually happened to us on several occasions. The longest one ago actually was in Amherst out in Western Mass, and we presented a project, a special permit hearing. All the neighbors got up. It got nasty. It got personal. Like you said, they had their right to do that, but that's not to say it was, you know, nice or productive or, in this case, true. And that one ended up, the folks decided not to build and left town. The town of Amherst, the zoning board, changed their rules three or 4 months later at their next town hearing, because they recognize that the special permit process is not productive. So we're really lucky here that that is going away. And if your town chooses to do a site plan review, it is more of that formal rubber stamping. What's not listed here, and like you brought up, Michael, is a great point. The other path here is just by right. You check all your boxes and go to the building department and get that permit. So we're talking about getting rid of the special permit, possibly adding a site plan review, but that's not a necessary step if your town doesn't allow that. By right means you're just going right to the building department, surveyed plan if they require it, engineered plans, septic plans if you need, and then any other pieces of that building permit that they require. So by right, easy.
Questions too, sorry,
Go ahead.
that are pertain to this. The first is, if a town has a zone that allows a single family by right and two family by right in the same district, can you add an ADU to a lot that already has a two family located on it?
That's a great question, and Rick and I see this in many towns. Some towns, written into their bylaws, they say, yes, you can do an ADU in single and two family properties where that's allowed. Other towns are a bit more explicit and say only in single family districts.
So that doesn't change based on this.
Right. So a town could say this is in single family zoning districts. The town may still say, well, you can't do this in a two family district.
The other one was, can you please explain appeal rights under site plan review versus special permit, plus the schedule for hearings and decision-making for site plan versus special permit?
Michael, could you take that one?
Oh, God. One land court judge, a brilliant judge, has described site plan review appeal procedure as the ghost haunting Massachusetts land use law. If a special permit is denied, you go straight to court. If site plan review is denied, or they impose conditions you think amount to a denial or that are too onerous and you can't live with them, if the local zoning ordinance or bylaw says you can go straight to court, then you can go straight to court. Otherwise, for technical legal reasons, it would take me half an hour to get into. If the zoning bylaw or ordinance doesn't tell you you can go straight to court, you then have to apply for a building permit anyway, which will be denied because site plan review is denied. Then you have to appeal the building permit to the zoning board of appeals, which will basically be sitting there saying, what are you doing wasting our time? You've been denied twice. We can't give it to you. They will deny it. But under the law, once you're denied the appeal from a denial of a building permit by the zoning board of appeals, you can take that to court. And I think some municipalities use that very cleverly as a way of enhancing their ability to deny site plan approval, right? Because what you then have to do is go from what's called permit level plans. I mean, you have to get a building, to apply for a building permit, you got to pay the fees, you got to have everything as if you're going to build it. And you know, at least at that point, it's an exercise in futility. And then before the zoning board, for sure now, you've got a public hearing with mailed and published notice. And that's where you're going to hear from the neighbors again too, potentially.
And I'd add in there, when we've done this before in just, I guess I was going to say both circumstances, but I think it was just the special permit is, where do you find that middle ground? Maybe you continue your hearing, maybe you go back to the drawing board a little bit. You know, you've heard some feedback from the neighbors, and where can you make modifications to make, you know, to build bridges here, to not have to go down that 3-step denial process that, like Michael said, gets increasingly more expensive, right? Because you have to now have stamped plans, you now have to pay fees, and that time adds up for all those hearings.
I'm wondering if it's even more beneficial for that energy to be put in showing up to town hearings to try and change things before, like that same amount of time and energy without all the money, or even waiting a year for things to change. And doing
Now is the time to go talk to your town planning department and put your 2 cents in. Rick and I were at the Housing to Protect Cape Cod conference last week, where the housing secretary, who was instrumental in getting this passed, was there. And he said as much. He said, now is the time where the change is happening. So go talk to your local folks. Your town may not need site plan review. Some towns already have it, and I'm imagining they're going to keep it. But other towns, if they don't have it now, they don't need to adopt that. It can just be that by right building permit process. Yeah. Did that answer the question?
I think so. Yeah.
Got where we needed to go.
I believe so.
And I would just add planning wise, that site plan review, you may still need to submit your documents a month in advance, or a few weeks in advance, have that hearing. There may still be an appeal period after. So looking at that overall time to turn an idea into a housing unit, the site plan review still would add time, just maybe not as much time as a special permit, especially if you get into nasty neighbors and continuances and all that fun stuff. Great. So timing and next steps. The governor signed it August 6th, and you talked about it earlier, Michael, of February being this deadline. So can you just elaborate here on sort of what's the timeline for towns and how does that look across
February 2nd, 2025. If that date comes and any town official tells you, well, you're going to have to wait till we change our zoning to bring it into compliance with state law, mindful of the maxim that free advice may be worth about what you pay for it, let me give you a quotation that I will cite. The court case, and it's in the recording, Attorney General versus inhabitants of town of Dover. Attorney General versus inhabitants of town of Dover. That case was decided in 1951, but it's still good law. Volume 327 of the Massachusetts Reports, beginning at page 601, and the statement I'm about to read is at pages 603 to 604, where it says that if there is something local that contradicts what we've been talking about, the law is and will be as of February 2nd, it becomes invalid immediately upon the taking effect of the statute. In other words, and this is a key point to what Tim was saying, if you live in a municipality that has a special permit ADU requirement, but no site plan review, as of February 2nd, go apply for a building permit. And they have no right to deny you. They might try to do that, but they cannot do it legally. You do not have to wait for a municipality to change things. Now, in cities where the city council can do this by vote, and they have a planning staff, they may be more able to get their act together. My guess is in towns where there are town meetings, there are going to be a lot of them that are not going to have their zoning changed by the beginning of February, especially towns that may be too small to have a very large planning staff. But be forewarned, they may try to tell you what is not correct. Do not be put off. Thank you.
And I'd add to that, how sort of Backyard ADUs is structuring ourselves to be able to help people is that building permit requires a lot of documents. You need that stamp, survey plan if it's required, your drawings, all your sort of permit packet. And you can start on that now, whether that's doing a feasibility study and sort of looking at big picture, what's possible on my lot, what are the utilities, what are all the things I have to consider, and backing into costs, say, hey, do I have enough information to decide to go forward with this? And that's a good way if your town currently doesn't have ADU rules or they're very restrictive, and we know they're going to change, that this is going to change the tide here, that you can start doing these pieces of the puzzle that are going to help you gather information and to gather knowledge to say, hey, I'm actually ready to go do this, and to start, designing and moving forward.
And if they're not prepared, let me be frank, because a lawyer is supposed to be a zealous advocate within the bounds of the law. If you can catch your municipality unprepared, and as Tim said, start your planning now and get that application in February 2nd or 3rd, by all means do it. That's perfectly legitimate, and it helps to be first, by the way, too. Don't wait till the 4th, 5th, or 6th, because by that time, they may be calling a special town meeting, or the city council may be holding emergency sessions. You want to try to get in there first, because my recollection is once you apply for the building permit, is it 30 days that they have to either approve it or deny it?
Yeah, that's typical. I don't know the exact number of days, but they have, their time window to review that application. And
Start
so
now. And
I feel pretty
and
lucky
fast.
too, because Maine, when they passed their by right ADU law, they gave all the towns 2 years, 2 years to
Whoa,
comply.
what?
Yeah.
Oh, look at you sending the balloons off. Because it was first passed with the new year with July 1st as the deadline, which then everyone pitched a fit, which got pushed to January 1st of the following year, which for some towns, but if you needed voting to make it happen, it got pushed to July 1st of that second year. So
Yeah.
and
So
that's what
we're
I
lucky to
pitched.
have, we're lucky to have such strong advocacy for housing at the state level. And so this 6-month period, basically, all of those towns that I talked to, they're like, yep, we're working on it, or it's already in play. I think one town down here on Cape has already come into compliance. So it's happening right now. If you're not sure about what your local rules are, feel free to reach out to Rick or I, but you could also, like Michael said, dive into that zoning bylaw. What are the rules now? And know that, hey, this baseline by February is going to change.
We have some more questions too. Does site plan review require a simple majority vote for approval by the planning board? And
Yes.
how does, you said that yes?
Yeah, I mean, it's a creature of local zoning, so it's conceivable it may require what's called a supermajority, which is a unanimous vote of a 3-member board, 4 out of 5, 2/3 of a larger board. But in almost every instance where I've ever seen site plan review, it's a simple majority, which unfortunately makes it easier to deny it if they want to get on a high horse and throw obstacles in your path.
And then the rest of it was, how about the municipal option that site plan review is handled by a zoning administrator instead of a board? Is that common in Massachusetts?
Nobody calls me when that happens, so dive in, guys, please.
Yeah, well, I've mostly seen by right building permits, or if it is that site plan review. I'm trying to think if it's gone through the planning office just administratively.
It usually goes through the planning board. What I've certainly seen on occasion is where it's just a planning board business meeting. They don't have to have a public hearing with published and mailed notice. If you're talking about just going to the zoning administrator, who's usually the same person as the building commissioner, that sounds like just going in and getting a building permit.
Yep, and just having that administrator review. Sorry, Rick.
No, I was supporting what Michael said. I've done them several times that I've had to go forward to the planning board for hearings, and it's always been a group that we've had to present to. It was never one individual from zoning or one individual from building. It was always a group of individuals that had to review.
What other great questions are out there, April?
This one seems like it's needing some clarity around some things that were said, but when the law changes in February and I by right can file for a building permit, am I correct that it can be denied by the building commissioner, which would then require the petitioner to go to the ZBA?
Yes, I mean, as a practical matter, they can do what they want. And if, for example, and this is part of the sadder aspects, you know, the way you kill any real estate project is you drag it out and you increase the costs. And so if, for example, the building commissioner, who generally works at the pleasure of the mayor or the select board or the town manager, is told, make life difficult, I suspect they're going to do that. Okay. It isn't pretty. It isn't legal, but I'm trying to be realistic. You know, I think we all know sometimes the way the world works isn't the way it's supposed to. Hopefully it won't happen, but this is Massachusetts. We, you know, like some other states, we have a long history of difference between what's right and legal and the way things really work.
And when we get into all this, you know, we're talking about special permits and neighbors, and I always try to bring the narrative back to housing. We've only built one of these as a rental in however many years. It's primarily for multi-generational living, for bringing families and communities closer. So I always just try to bring that human element in, you know, whether that is to the building commissioner, whether it's to, you know, the planning board. Just circling back, what's the story here? That's important too.
Another question is, how could the Executive Office of Housing issuing regulations or guidelines impact the implementation of this law on a local level?
That's a really great question. When Rick and I were at that conference with the secretary, he was saying, we're soliciting your feedback. Reach out to them. They want to hear our feedback as constituents. Of what works and what doesn't work. He didn't really flip the script there to say what their impact would be, besides to listen and take feedback. So I don't.
They have a specific website that they were going to be having made available, and we'll have to, maybe we can post that onto our site, April.
I did some looking beforehand and I couldn't find it yet, but that doesn't mean it's there.
Cool.
So
we'll track it down and get it to you, April. Then we can post it.
Send that out for sure. And this question's been waiting since the very beginning. But my town has already approved ADUs, but only a handful have been built. Is there any supplemental funding for homeowners to finance ADUs in and under the Affordable Homes Act?
there is a lot of money allocated as part of the Affordable Homes Act. I'm not a total expert on it, but from what I've read and learned, there is a subsect of funds in there. Is about $60 million that was used to refill the coffers of the Home Modification Loan Program, or the HMLP for short. That is for folks who are elderly or have a disability, and you can, if you're eligible, tap into that fund and get up to $50,000 at 0% interest. So you can use those funds if you qualify to build an ADU. From the rest of the law, and again, I haven't read all of those funding allocations. I haven't seen anything that goes directly to all of us here in Massachusetts to build.
I will do a plug because December 19th, this is part of a series. This is our first night of a series. We're going to be doing one a month specific to the Affordable Homes Act and this law passing. So December 19th, it's another Thursday at 5 o'clock. We're doing a financing event. So we will have financing people to come in and stand and kind of support Rick and Tim in the background, the same that Michael's doing this evening. So that should be helpful with getting that financing information to you too. So
and there are certain towns even before the Affordable Homes Act that have ADU programs. So I did have a quick slide here on that of this would be our advocacy arm, is to go to the state and say, hey, this is all about housing. You're allowing ADU by right, but you haven't funded them. At the state, it would be fantastic if they could create a financing program. They're already, the HMLP is a great example. There is a deferred 0% interest loan that doesn't have an impact on the state budget as a revolving loan. There could be a forgiveness element built in there. Deed restrictions do sometimes impair this. because, homes are usually everyone's largest asset, and making the application process easy. So we'll continue in the background to be doing, advocacy here to try to get ADUs funded. We are biased, right? We are the ADU people, but genuinely, this is going to be a great way for housing that works in our communities.
And anyone that's been to our Cape Cod in-person events, Talitha is on right now. She's making some great points in the Q&A. Just that Western states have been ahead of us on this, and usually money has opened up after the buy right has passed, so it's on its way, she says. Thanks, Talitha. Glad you're here.
Yeah.
Yeah. All right, I think that's it. We got all of our questions answered. Is anything you all would like to add before we hop off?
I would just say build more ADUs. Genuinely, whether that's with backyard ADUs or anyone else, it's an amazing form of housing. At the end of the day, what I like about my job is we're helping people figure out, a key component of their life, which is housing and stability. So I want to thank you, Michael, for joining us tonight, for lending your expertise.
Thank you.
There is a memo that Michael wrote, and we will share that with everyone who is here tonight. It's a great several page legal, would you call that legal advice, or just a legal document?
The reason we're so careful is, I'm liable for legal advice, and it's a little like you call the doctor, "Doc, can't you tell me what's wrong?" And the answer is no. You need to come into the office. I have to examine you. I have to run tests, and then I can diagnose. Legal advice depends greatly on the particular circumstances of a case. What municipality are you in? What do you want to do? Sewer or septic? What, as Tim has helped me understand, what are the Department of Public Works water and sewer requirements? There's so many variables that legal advice has to be given in response to a particular set of facts. So that memorandum is general information. Thank you.
Great. Well, thank you everyone for taking the time this evening to join us. Thank you for your great questions.
Advocate. Everyone go speak to your town officials. That's how things happen faster. I also am doing a plug 2 weeks from tonight. We're talking about feasibility studies. So if you are interested in building, we're having a feasibility virtual event. Again, 2 weeks from today, you can sign up for that now at backyardadus.com/events. And we'll be picking someone live to do a live mini version of a feasibility study. If you're interested in that, all the directions are on our website. And then 2 weeks after that, we're back here for the permitting and construction, realities of permitting and construction is the title, for the Affordable Homes Act. So the next part in the series as well. Sorry, we got to let everyone know all the things.
Yeah, great.
April.
Awesome.
Great.
Well, thank you, everybody.
Thank you so much. Thanks for joining us. Have a good night.